Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we are going to discuss important issues appearing in the New Delhi edition of the Hindu newspaper dated 21st July 2018. Let's begin. The first news appears on page number 1 and also appears as a continuation in two parts on page number 7. So, in this particular news, it's basically about limits on WhatsApp messages, curbing fake news, as well as preventing misuse of WhatsApp, especially during election process. And in this respect, the WhatsApp has also informed our Election Commission of India that it's very serious with respect to curbing menace of fake news because of late misuse of WhatsApp has caused public lynching. Hence, to tackle the issue of spread of false or fake news, WhatsApp has started experimenting regarding limit on the number of chats. So to tackle the issue of spread of false news or fake news, WhatsApp has started experimenting regarding limit on number of chats, messages, pics, videos which can be forwarded. So in this news, let's find out about the cap on these WhatsApp messages as well as steps also taken by the Election Commission of India. So now as per the experiment of WhatsApp, there will be a limit on message forwarding in a bid to reduce the spread of misinformation. And in this respect, WhatsApp is testing a limit of 5 chats with respect to India. Whereas with respect to the rest of the world, the cap on the chats will be that of 20. So this difference of capping of messages in India at 5 and in rest of the world at 20 tells us the story about our understanding of use and impact of social media as compared to rest of the world. And also the fact that the forward messages in India has created most havoc with respect to lynching, which is not the case in most of the other countries. So this entire issue of limiting WhatsApp messages becomes important with respect to security issue. As you can see in this picture, it says that there will be a limit on message forwarding in a bid to reduce the spread of misinformation. And in this respect, WhatsApp is testing a limit of 5 chats in India. An interesting fact here is that WhatsApp says that more messages are forwarded in India than any other country. Now this again becomes very interesting with respect to cases of lynching and its link with forwarded messages. It has further said that it has put a limit of 20 chats for the rest of the world, whereas for India it is just 5. With respect to capping WhatsApp messages, it has said that initially WhatsApp was supposed to be a private messaging app, but now these WhatsApp messages are used on large scale for public misuse as well as spreading false news or fake news, which has eventually resulted in death of people due to cases of mass lynching. So as per WhatsApp, the main purpose of capping these WhatsApp messages is to prevent its misuse. To prevent the misuse of WhatsApp during election, it has also informed the Election Commission of India that it will take various steps ahead of the polls to prevent misuse of its messaging platform, as it also brings a bad name to their organization. And in this respect, WhatsApp aims to bring India its fake news verification model, which is also being used at other places, as it is also used during the elections of Mexico as well as Brazil. And in this respect, WhatsApp has also informed the Election Commission of India that it will be watchful of spam messaging techniques so as to ensure that these WhatsApp messages are being misused or forwarded either by people or through bots. So in this entire news regarding capping of messages by WhatsApp becomes extremely important regarding the backdrop of misuse of forwarded messages or spread of fake news, which has also resulted in cases of mass lynching. It also becomes important that even the Election Commission of India has recently introduced an app known as C-Vigil. And the purpose of this C-Vigil app is to report cases of online violations of Model Code of Conduct, where citizens can click picture or video and post it on the app itself during the conduct of elections. Important feature in this is that this app, that is C-Vigil app, will be activated in only those states where elections are to be held and Model Code of Conduct is in place. So this becomes an extremely important measure by the Election Commission to ensure conduct of free and fair election, and also to ensure that violations, if any are taking place, can be curbed directly by the participation of citizens. Another important fact about this C-Vigil app is that you cannot upload forwarded messages on this particular app. So this app by the Election Commission of India becomes extremely important. It says it is an online application for citizens to report on Model Code of Conduct violations during the election period. The application is called C-Vigil denoting vigilant citizen and the proactive and responsible role they can play in the conduct of free and fair elections. It further says by using this particular app, citizens can promptly report unlawful campaign activities within minutes of having witnessed them. And how this will help? This will enable the flying squads to reach the spot in a matter of few minutes, as it will help in saving time and also providing prompt action by the election officials. So this app of C Vigil again becomes very important with respect to conduct of free and fair election. So in this news we saw that WhatsApp is aiming to limit the number of messages on WhatsApp in order to curb fake news and also to prevent misuse of WhatsApp. And in the process, they have also informed Election Commission of India that will try to prevent the misuse of WhatsApp during elections. And for that respect, WhatsApp is also planning to bring to India its fake news verification model. So this news becomes extremely important with respect to security as well as conduct of free and fair election in the country. As far as the syllabus is concerned, it comes under GS paper 3, specifically under challenges to internal security through communication networks, role of media and social networking sites in internal security challenges, and also gets covered under GS paper 2 with respect to elections. Thus this news on WhatsApp becomes very important from a UPSC exam point of view. With this, let's move on to the next news. The next news appears on page number 8 in the article section. It reads, Faultlines in a landmark judgment. The verdict on SC/ST Atrocities Act marks the collapse of the constitutional scheme to protect the weaker sections. Now, in this particular article, the author tries to bring a critical analysis of the judgment provided on the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act, as it provided for certain additional safeguard for the accused under this particular act, that is SC and ST Prevention of Atrocities Act 1989. The judgment triggered a nationwide protest across the country and created a sense of insecurity and fear among the vulnerable sections of the society. So in this article, let us understand the viewpoint of the author, how he has tried to analyze this judgment and how this particular judgment has created this sense of insecurity as well as fear among the vulnerable sections of the society, mainly the scheduled caste, scheduled tribes as well as the Dalits. So as per the author, the primary aim of the judgment was to protect the innocent officers as well as employees in government as well as private sectors from the misuse of Atrocities Act. It further says that this particular judgment ended up conveying certain facts to the people. And further, as per the author, this judgment ended up conveying a false and dangerous message that the Prevention of Atrocities Act is a charter for exploitation or oppression and an instrument of blackmail or to wreak personal vengeance. So these were the reasons why this particular judgment created a nationwide protest by the members of SC, ST as well as other vulnerable sections of the society. The author further suggests about certain misleading assumptions which have been taken in the judgment, which has further made this SC, ST and vulnerable sections more unsecured. The author suggests that the court appears to have mistaken a large number of acquittals in the atrocities case to be false cases. So first and foremost, it says that most of the accused who were acquitted, these were charged under false cases. So this gave an impression that these cases of atrocities filed by members of SC and ST were mostly frivolous cases. It further says that there is a lack of precise data on the scale and extent to which the act has been misused by SC, ST employees. So this author suggests that as of now, there is no proper data to ascertain this acquisition or conviction with respect to cases under this Atrocities Act. And the author further suggests that the parameter to determine that a case filed under the Atrocities Act was with bad intent. So the author effectively says that as of now, there is no set parameter to determine that a case filed under the Atrocities Act is with bad intent or is malified. Thus, according to the author, all these points led to certain misleading assumptions with respect to the judgment on this particular case. So in this article, the author has effectively said that without looking into reasons and data on conviction as well as acquittal under this act, the judgment effectively amounted to the case of judicial legislation. The author further suggests that this could have been avoided either by ordering an inquiry into the facts and reasons of the case or by referring the matter to a larger bench. So the author says that since this impacted a vulnerable section of the society who are also protected by the constitution, hence this particular case could have been either given to a larger bench or a proper inquiry could have been constituted with respect to ascertaining the facts of the case. The author further suggests that the court should have consulted the Scheduled Caste as well as Scheduled Tribe Commission on matters affecting their interest as mandated by the Constitution under Article 338 as well as 338A. Now, this Article 338A with respect to Scheduled Tribe Commission was added by the Constitution 89th Amendment. So this news articles on fault lines in landmark judgment becomes very important as it provides a critical analysis of this particular judgment, and a similar question can be asked in your examination with respect to this particular judgment, as the judgment has created a nationwide protest specifically among the SC, ST and the vulnerable sections of the society, as it has created certain amount of insecurity as well as fear in them. It forms a part of GS paper 2 specifically under welfare schemes for vulnerable sections of the population by the sentence states, mechanism, laws, institutions and bodies constituted for the protection and betterment of these vulnerable sections, and also under significant provisions of the Constitution of India, specifically Article 338 and Article 338A. Now, the critical analysis of this particular judgment becomes important to understand because UPSC has asked questions on similar lines, especially in the year 2017, where it asked critically examine the Supreme Court's judgment on National Judicial Appointments Commission Act 2014 with reference to appointment of judges of the higher judiciary in India. So we understand that some of the important judgments or some of the landmark judgments becomes important to not only understand but also analyze that how it impacts members of the society as well as how the authorities as well as the citizens perceive certain judgment of the Supreme Court of India, as it has its impact on day-to-day lives of citizens. So this article, fault lines in a landmark judgment, becomes very important. With this, let's move on to the next news. The next news appears on page number 9. The news reads, Counting the Tiger. So this news pertains to 4th All India Tiger Estimation or Tiger Census. So earlier, there have been 3 tiger census, mainly in the year 2006, then in the year 2010, and again in the year 2014, and now the 4th All India Tiger Estimation is being done in the year 2018, that is this very year. However, this news pertains to counting of tigers in India on the eve of 4th National Tiger Census, and according to Wildlife Institute of India as well as National Tiger Conservation Authority, India's tiger population has been observed to increase at the rate of around 5.8% since 2006. So roughly we have seen an increment of roughly 6% in terms of tiger population. The estimation in 2014 pegged tiger numbers at 2,226. However, in this particular article, the author has suggested that the increase in this tiger estimates could have been just a byproduct of changes in the survey method. So effectively, the author in this article is talking that because of change in survey method, there could have been an increase in tiger census or tiger population, and this change of survey method pertains to such as deployment of more camera traps, changes in analytical methods, etc. So this is a very elaborate news discussed regarding different mechanism how to conduct the tiger census. From our UPSC point of view, this article contains certain important topics because questions have been asked by UPSC specifically in the prelims examination. So in the backdrop of this 4th Tiger Census, let us understand some of the important terms mentioned in this particular news so as to keep ourselves updated with the day-to-day happening of All India Tiger Estimation of 2018. So this news is talking about change in various methods with respect to counting of tigers. Earlier, they used to count the pug marks of tiger, but now they have come to this method known as camera traps. A camera trap is a remotely activated camera that is equipped with a motion sensor or an infrared sensor and uses a light beam as a trigger. Camera trapping is a method for capturing wild animals on film when researchers are not present and has been used in ecological research for decades. This is widely used in tiger census. So we know that in the tiger census, another method to count these tigers is known as camera traps. Further, in the very beginning of this news, it talks about Annamalai Tiger Reserve. Let us understand few basic points about Annamalai Tiger Reserve. It says, that this tiger reserve, which was earlier known as Indira Gandhi Wildlife Sanctuary and National Park, is a protected area located in Annamalai Hills in the Tamil Nadu. So this Annamalai Hills is in Tamil Nadu. This becomes an important fact from your prelims point of view. Further, the tribes which reside in this Annamalai Tiger Reserve. It has significant anthropological diversity with more than 4600 Adivasi people from 6 tribes of indigenous people living in 34 settlements. The tribes are Kadars, Malasars, Malai Malasars, Pulayars, Muduwars and the Eraval. So please remember these different tribes which reside in the Annamalai Tiger Reserve. Further, threatened species. The endangered Bengal tiger, Indian elephant, dhole, that is Asiatic wild dog, Nilgihir tar and lion-tailed macaque. On these questions have been asked by UPSC previously. Flora. The park is also home to a wide variety of flora and fauna, typical of the southwestern Ghats. Wet evergreen forest and semi-evergreen forest, montane shola grassland, moist deciduous, dry deciduous, thorn forest and marshes. So we see in this Annamalai Tiger Reserve, we find a variety of flora as well as fauna. So after understanding and going through Annamalai Tiger Reserve, let's find out about other important terms. So this news also mentions about National Tiger Conservation Authority, that is NTCA. So this National Tiger Conservation Authority is a statutory body under the Ministry of Environment, Forest and Climate Change. This becomes a very important key information that this institution, that is National Tiger Conservation Authority, is under the Ministry of Environment, Forest and Climate Change. It is constituted under enabling provision of the Wildlife Protection Act 1972. Another important aspect. It's constituted under Wildlife Protection Act 1972. Further, it says the aim is to strengthen tiger conservation as per powers and function assigned to it under the said act. So its main aims is to strengthen tiger conservation. Further, the objectives of National Tiger Conservation Authority are to provide statutory authority to protect tiger so that compliance of its directive becomes legal. So it ensures compliance of its directives with respect to tiger conservation. Further, fostering accountability of center state in management of tiger reserves by providing a basis for memorandum of understanding with states within our federal structure. So it also coordinates with the states for protection of tigers in their respective tiger reserves. Further, it also addresses livelihood interest of local people in areas surrounding these tiger reserves. So these are some of the important objectives of National Tiger Conservation Authority. Further, this news also mentions about Wildlife Institute of India. The Wildlife Institute of India is an autonomous institution under the Ministry of Environment, Forest, Climate Change, and it was established in 1982. Wildlife Institute of India is an internationally acclaimed institution which offers training program, academic courses and advisory in wildlife research as well as management. An institute is actively engaged in research across the breadth of the country on biodiversity related issues. So it again becomes important to know about Wildlife Institute of India. Further, the aims and objectives of Wildlife Institute of India are to build up scientific knowledge on wildlife resources, train personnel at various levels for conservation and management of wildlife, carry out research relevant to management, including the development of techniques appropriate to Indian conditions, provide information and advice on specific wildlife management problems, collaborate with international organizations on wildlife research, management, and training, and to develop as a regional center of international importance on wildlife and natural resource conservation. So all these aims and objectives with respect to Wildlife Institute of India becomes extremely important. So all these aims and objectives with respect to Wildlife Institute of India becomes extremely important. So apart from these institutions which have been mentioned, it also becomes important to understand that for the first time India will be conducting the census along with other tiger range countries, namely Nepal, Bhutan and Bangladesh. So this again becomes a key information that India will be conducting its 4th tiger census along with other tiger range countries, namely Nepal, Bhutan as well as Bangladesh. With this, we have seen some of the important institutions which have been mentioned in this particular news. Let's go through some of the UPSC questions as have been asked. Now these questions have been asked in the year 2017 itself. The question was, in India, if a species of tortoise is declared protected under Schedule 1 of the Wildlife Protection Act 1972, what does it imply? The options given were, it enjoys same level of protection as the tiger, It no longer exists in the wild. A few individuals are under captive protection, and now it is impossible to prevent its extinction. It is endemic to a particular region of India, and both B and C stated above are correct in this context. No, the correct answer here was A, that is, it enjoys the same level of protection as the tiger. Further, another question was asked on M stripes. The term M stripes is sometimes seen in the news in the context of. The answer here was maintenance of tiger reserve. And in this, M stripes stand for Monitoring System for Tigers, Intensive Protection and Ecological Status. And M stripes is a software based monitoring system. And this was launched by NTCA, that is National Tiger Conservation Authority. Thus, we see important questions have been asked by UPSC from this article which has appeared in today's newspaper. So even though this is a very elaborate news with respect to different mechanisms adopted in tiger census, however, certain key information becomes important from us from a UPSC point of view. As far as the syllabus is concerned, it gets covered under GS paper 3 under environment and specifically under conservation. Thus, this news on counting the tiger becomes extremely important with respect to certain important institutions mentioned in this particular news. With this, let's move on to the next news. The next news appears on page number 13. The news reads, GST Council may mull taxing natural gas. Rationalization of rates on sanitary pads, handicraft may also figure in this meeting. So, in this particular news, the 28th meeting of GST Council is scheduled to take place today. And this meeting is likely to discuss the inclusion of natural gas in GST, rationalization of tax on certain items including the sanitary pads as well as handicraft items, and simplification of procedure to file GST returns. So let us see this key issue one by one. In the discussion around inclusion of natural gas, the Council is likely to consider bringing aviation turbine fuel and natural gas under the ambit of GST, that is Goods and Services Tax. However, the tax slab has become a deterrent to include ATF, that is aviation turbine fuel, as well as natural gas under the ambit of GST. In this regard, it is important to know that when GST was implemented last year, 5 commodities, namely crude oil, natural gas, petrol, diesel, and ATF, that is aviation turbine fuel, were kept out of its purview for the time being. Hence, today's meeting is with respect to considering to take back ATF as well as natural gas under the ambit of Goods and Services Tax. Now, the further issue is with respect to taxing of sanitary pads. In this respect, the Ministry of Women and Child Development has reportedly requested the Council to reconsider its earlier position and reduce the tax rate on sanitary pads from 12 to 5%. However, in this regard, the centre had earlier argued that reducing the tax on sanitary pads would result in an inverted duty structure where the inputs have a higher tax rate than the final product. So, in an inverted duty structure, the tax on inputs, that is raw materials, is much more as compared to the tax on the final goods or the finished product. And in the case of sanitary pads, inputs on some of the raw material is attracted at the rate of 18%, whereas GST is charged at a rate of 12% on the finished product. Hence, it is a clear example of inverted duty structure. So, this is what the argument of the central government is, that reducing tax rate on sanitary pads will result in an inverted duty structure where inputs have a higher tax rate than the final product. So all these key points will be considered in today's meeting of the GST Council. So let's wait and watch what the GST Council ultimately decides with these key parameters, that is inclusion of natural gas under GST, rationalization of tax with respect to certain items such as sanitary pads as well as handicrafts, and also with respect to simplification of procedure to file GST returns. This topic forms part under GS paper 3, specifically under Indian economy and issues related to planning, mobilization, resources, growth, development and employment. Thus, this is a developing story. Let's wait and watch for the final decision of the GST Council. With this, let's move on to the next news. The next news appears on page number 7. The news reads, Cryptocurrencies will boost illegal transactions. RBI to the Supreme Court of India. They said they are immune from government interference. So this news on cryptocurrencies becomes important because questions directly have been asked by UPSC in the prelims of 2016 as well as 18. We'll see those questions. First of all, let us understand what has the RBI told the Supreme Court with respect to cryptocurrencies. So in an ongoing case, RBI has presented its argument against the use of cryptocurrencies. RBI is warned dealing in cryptocurrencies will encourage illegal transactions. as we cannot know the source of this particular transaction. Further, RBI said that it has already issued a circular prohibiting use of these virtual currencies, including Bitcoin. So, Bitcoin is also a form of virtual currency, and as of now, Bitcoin is beyond the purview of our central bank, that is, Reserve Bank of India. RBI in the said circular has also clarified that it has not given any license or authorization to any entity or company to operate such schemes with respect to virtual currency or to deal with Bitcoin or any other virtual currency. Thus, RBI has strictly prohibited the use of virtual currencies by banks, financial institutions, or any companies who deal with these virtual currencies. So, dealing in virtual currency in India is prohibited by the Reserve Bank of India. In this respect, RBI has also cautioned its users, holders, as well as traders of virtual currencies, including bitcoins, with respect to various risks associated in dealing with such virtual currencies. And these risks can be in the nature of potential economic risk, financial risk, operational risk, legal risk, customer protection risk, as well as security related risk. So RBI has effectively cautioned users, holders, as well as traders of virtual currencies, including that of bitcoins, as it poses certain legal risk, operational risk, financial and economic risk, customer protection risk, as well as risk related with security. In this respect, RBI has directed the banks as well as financial institutions to freeze the bank accounts of those individuals or companies who are dealing in illegal trade of virtual currencies. So RBI has effectively said that if anyone is dealing in these virtual currencies, then their bank accounts shall be freezed. Now these cryptocurrencies are a stateless digital currency in which encryption techniques are used. In which encryption techniques are used for trading. So basically they use this encryption technique. Further it says, as of now these virtual currencies operate independently without supervision from RBI. So any operation of virtual currency in India beyond the supervision of RBI becomes an illegal activity or a criminal activity. So RBI has said that if any individual or company is using these virtual currencies, then their account shall be freezed, and any virtual currency being used in India is beyond the purview of RBI, hence becomes an illegal or a criminal activity. In this respect, the Department of Economic Affairs under the Ministry of Finance has constituted an interdisciplinary committee basically to regulate use of cryptocurrencies in India. And this committee is an interdisciplinary committee under the chairmanship of Secretary of Economic Affairs. The aim of the committee is to take stock of present status of virtual currencies both in India as well as globally, to examine existing global regulatory and legal structures governing virtual currencies, to suggest measures for dealing with such virtual currencies, including issues relating to consumer protection, money laundering, etc., as well as to examine any other matter related to virtual currencies which may be relevant in the present circumstances. So the government had constituted a committee to take stock of the virtual currency both in India as well as globally, as well as to examine any regulatory or legal structure which can be used to govern these virtual currencies. Now this topic of virtual currencies, as mentioned, becomes important because questions have been asked by UPSC in the prelims examination. Let's go through the questions. Now this question was asked by UPSC in the year 2016. The question read, with reference to bitcoins sometimes seen in the news, which of the following statements are correct? The options are, bitcoins are tracked by central banks of the countries. No, bitcoins are not tracked by any of the central bank of the country, and this is a pressing concern with most of the countries including India, as we have just seen. Second, anyone with a bitcoin address can send and receive bitcoins from anyone else with a bitcoin address. Yes, that is why these currencies are encrypted. Third, online payments can be sent without either side knowing the identity of the other. Yes, this is also correct, and this is primarily one of the reasons why RBI is so worried with respect to secrecy behind the use of virtual currency. So the question asked, select the correct answer using the code given below. Here we see 2 and 3 is the correct answer. So here B was the correct answer. Further, a question again was asked in the year 2018, that is this very year. The question was, consider the following pairs: Belly 2 experiment, artificial intelligence, blockchain technology, digital or cryptocurrency, CRISPR or CS9, particle physics. Which of the pairs given above is correctly matched? Now in this we know that blockchain technology is correctly matched, but we are not sure about Belay 2 or CRISPR. So to understand that Belay 2 experiment relates with particle physics and Cas9 experiment pertains to changing of genes within an organism. So in this the question was which of the pairs given above are correctly matched. So the correct answer is 2 only. So we see this topic of cryptocurrency becomes very important. So any regulation or prohibition with respect to cryptocurrency by RBI becomes extremely important. This topic forms a part of GS paper 3 specifically under awareness in the field of technology as well as basics of cyber security and money laundering, as it is believed that cryptocurrencies can also be used in money laundering process. So RBI has issued a circular to prohibit the use of these cryptocurrencies. Thus, this news on cryptocurrency become very important. With this, we come to an end to discussion of today's newspaper. Please subscribe to our channel and press the bell icon for daily DNS updates. With this, let's move on to the question for the day.